All right, so Mr. Montcastle, Ms. Montcastle, your attorney is now here. He's going to confer with the state, and then when he's ready, we'll have him approach.
Okay, thank you. I'd like to confer with my attorney as well, please.
All right, thank you. Just give us a moment. Terrell Allen.
How are you doing?
Oh, I'm doing okay. How are you doing?
I'm alive.
Oh, yeah. Are you all ready to proceed? No problem. So y'all are proceeding on the motion to revoke?
Yes, Judge.
All right, the court is calling 2015 CR 3927 State versus Terrell Allen. Can I have parties announce?
Duffy Pitlock for the state of Texas.
Brad Thornton for Mr. Allen.
And are you Mr. Allen?
Yeah.
All right. Are you the same Mr. Allen who was placed on community supervision in 2015 CR 3927 for the offense of burglary of a habitation on March 19, 2019 for a period of 3 years? Is that you?
Yeah, yes, ma'am. Yes, Your Honor.
All right, state.
Judge, we also have.
Ms. Montcastle, what are you doing? Ms. Montcastle.
Okay, yes.
There's another motion to revoke.
Oh, there's a second motion?
No, there's a second case. It's a DWI.
Oh, I have it. Yeah. And the court is also calling 2019 CR 10147W. Did you review the motion to revoke community supervision in that case as well?
Yes, Your Honor.
Are you the same Terrell Allen who was placed on community supervision in 2019 CR 10147W for the offense of driving while intoxicated third or more on October 11, 2019 for a term of 8 years? Is that you?
Yes, Your Honor.
All right. And excuse me, could I get a file stamp for motion to revoke? And state, are you proceeding on the same allegations in each motion?
Yes, Judge. The state intends on proceeding on one, waiving and abandoning, if you would, when the state can make that announcement.
All right, you may proceed.
So.
Oh, you're welcome, Mr. Payne.
For cause number 2015 CR 3927, the state will proceed on violation of condition number 2, but the state will waive and abandon the other violations alleged.
Any objections to the waivers?
No, Your Honor.
And then in cause number 2019 CR 10147W, the state will proceed on violation of condition number 2 and waive and abandon the remaining violations, Your Honor.
Any objection?
No, Your Honor.
All right, and state if you'll read the violation into the record, please.
Yes, violation number 2 for both cause numbers on or about the 24th day of February 2022 in Bexar County, Texas. The defendant, Terrell Allen, did then and there fail to submit to drug testing as directed by the supervision officer and or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that violation in each of the cause numbers, true or not true?
Sure, Your Honor.
Did you understand by pleading true to violation of condition number 2 and cause number 2015 CR 3927, the court could find it to grant the motion and sentence you up to 3 years in the prison? Knowing that, do you still wish to plead true to violation of condition number 2? Court will find violation of condition number 2 true. And cause number 2019 CR 10147W, did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion and sentence you up to 8 years in the prison?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 8?
Condition number 2.
I'm sorry, condition number 2. Knowing that, do you still wish to proceed with your plea of true to violation of condition number 2? All right, then the court will find violation of condition number 2 true. Is there a proposed agreement?
There is, Judge.
Yes.
It is different recommendations for the 2 cause numbers. For cause number 2015 CR 3927, the state is recommending termination unsuccessful, but defendant has already been sentenced on that one. The recommendation for cause number 2019 CR 10147W. The state is recommending continued probation, but to complete state ISF cognitive track followed by ISP.
All right, so are you saying that he's already been sentenced in cause number 2015 CR 3927?
The state does see that this is the second MTR and defendant was adjudicated from deferred.
Okay.
That's what we're under the impression of.
Yes, no, he's on regular probation or community supervision. And so his maximum sentence is 3 years in that cause number. So probation?
Judge, on that cause number, that case expired March 18th of 2022.
Okay.
The court is aware of that.
All right, so and cause number 2015 CR 3927, the court is finding it true. The court will terminate you unsatisfactorily. And just one moment. All right, so then let's move on to the 2019 CR 10147W. State you're requesting ISF?
Yes, Judge, cognitive track followed by ISP.
All right. Defense?
Your Honor, Mr. Allen, back in 2022, that was the day where there was an extremely bad snowstorm that occurred. And so they called him in to do a test, and he expressed that he didn't feel like he could do it safely that day and wanted to do it a different day. And so he made the decision not to do that. My client, all of the evaluations, we looked at it with probation, has never been evaluated for mental health issues. Yet in dealing with him and talking to his family, he definitely has severe issues. He's been diagnosed, my understanding from dealing with his family, with bipolar depression, as well as what I can see in my interactions with him is that very high levels of ADHD, being able to focus. And so what happened on that day was he was extremely worried, didn't know what to do, panic, couldn't deal with all the problems going on in his life, and decided to freeze and not know how to deal with that. And he hasn't had any issues since then. We think that the proper thing to deal with in the situation is to address those mental health issues now, and that he would be successful in the remaining terms of his probation, and that's what the freeze up was. It wasn't an issue of him using or being dirty. It was him legitimately being afraid because of the conditions on that particular day in terms of it being icy. And so we think that this is an appropriate way to remedy both of those situations, is to continue letting him be successful, but also with a cognitive track addressing the issues.
Thank you, may be excused.
Thank you, Judge.
Yes. Yes.
On the icy day, I have two kids, right? Of course, the kids have a mom. Mom was in middle school while mom was at the hospital. I only had me. It was me, the two kids, right? And of course, everyone seemed save the last dance with Julia Roberts, or yes. Okay, yeah. I can't drive, you know. I don't want to take my kids to you can't take your kids anywhere, can you? No, so I mean I was arguing with the probation officer. I was like, can I please go tomorrow? She's like, no, Mr. Allen, I have to go.
Okay, so here's the thing. You've been missing since 2019.
For this day.
So, but here's the thing. 2019, do the math. How many years have expired since 2019 and you still haven't come in? The only time you came in was because you were arrested.
22.
Right, Your Honor. And in dealing, and we can present testimony on this, Your Honor. I've talked to his family, interviewed them.
No, I'm just trying to let him know
Right.
that what he's giving me are excuses.
Absolutely.
And these are life. This is life, right? Everybody has different things they have to do in life, right? Now you have some people who say, oh, I'm not going to go to the store today. I'm not going to do this, but there are no real consequences for that. I mean, you don't have something to eat that day. But the consequences are you could potentially go to prison. So since from 2019 to now, have you gone to the grocery store?
Yes, Your Honor.
All right, so you found a way to do that, but you didn't find a way to contact your probation officer and come in. Since 2019 to now, have you taken your children to school? So you haven't taken them to school, so that means somebody else was taking them to school, so you could have come in. So don't come to me with excuses because you haven't done anything since 2019. You understand? Probation, what are you requesting?
Judge, the recommendation on Montgomery and Keith State item.
I mean, he hasn't been around since 2019.
We're under the impression it was 2022 when he filmed.
Was.
All right, so that's still not good because that's 3
He
years.
completed, he was on the very last end of drug court. In fact, he was waiting for the certificate
Mhm.
to graduate from the drug court.
No, and see, that's the other thing with drug court. I know they give people chances, and I know from drug court, and you correct me if I'm wrong, when you don't show up for something for drug court, they don't immediately put you out of the program.
And they helped me.
Yeah,
Your Honor, and I
but they
actually,
can't help you if they don't see you.
I appreciate you for recommending me to drug court, because that helped me out in my adult life, my whole life, really, discover a bunch of things. I didn't realize I had a problem. I always thought like, oh, I don't have, I just didn't want to stop, And
No, I
finally-
told you had a problem. That's why I sent you to drug court.
Yeah, I appreciate that, Your Honor. It did help me out tremendously. It's like, I always thought I was Superman. It's like, how many times have you heard, I'm pretty sure I get this a bunch, right? It's like, hey, man, you sound white. I'm like, I speak English.
No, I don't get people saying I sound white. If they say I sound white, then that's their prejudice that's coming out.
Mhm.
Because what does that mean to sound white? What are you trying to say?
I get it all the time, Your Honor. I'm sorry.
He's talking about himself, Your Honor.
No, okay, so he needs to sign the trial court certification. He hasn't signed that.
Oh.
And probation, did he pay the $57 restitution to SAPD?
Yes, Judge.
Okay. All right, state.
Yes, Judge.
All right, the court is going to grant the motion. Do y'all want to speak to years? His minimum is 8 years.
Judge, that is the full range. The state has no comment on the range.
All right, thank you. Maybe excuse. Yes,
Have you be permitted to present some brief testimony?
sure.
Okay, I'd like to call, Pamela Williams.
All right, here's your closing commentary in the style of Law Talk with Mike. That hearing had a little bit of everything. Terrell Allen came before Judge Boyd on 2 separate motions to revoke probation, one from a burglary case, the other a DWI third or more. The record went all the way back to 2015, and you could tell how long this struggle had been unfolding. Mr. Allen admitted he'd failed to submit to drug testing as required, and while his attorney tried to put the missed test in the context of a bad winter storm and severe anxiety, Judge Boyd kept bringing the discussion back to the big picture, years of noncompliance, not just one bad day. She pointed out that even if you freeze up in the moment, you still have to take responsibility. And the reality was that Mr. Allen hadn't reported in years, only coming back into the system after being arrested. The defense argued that Mr. Allen was near the finish line of drug court when this lapse occurred, and that he'd since had time to reflect and make changes, suggesting that continued probation and mental health treatment would be more constructive than prison. You could hear Mr. Allen himself acknowledging that drug court had opened his eyes to problems he hadn't wanted to face. He even said it helped him more than anything in his adult life. But Judge Boyd didn't let the conversation drift into excuses. She methodically walked through whether he'd managed to take his kids to school or get groceries during those same years, he claimed. He was too overwhelmed to report, and the answers were mostly yes, underscoring that he could have found a way to comply if he'd made it a priority. It was one of those exchanges you see in court that's not heated, but very honest. She was clear that drug court is designed to help people and to be patient with setbacks, but that help requires participation, and after years of absences, the court's options narrowed down. In the end, Judge Boyd granted the motion to revoke. For the older burglary case, the probation was terminated unsatisfactorily since the sentence had already expired. For the DWI, the sentencing range was substantial, up to 8 years. As of the close of this hearing, the court was still hearing testimony and weighing the final sentence, but the tone made it plain that no matter how sympathetic the underlying struggles, accountability still had to come first. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone, *.